Good evening and welcome. Welcome to our program this evening. I greet you as the Vice President for Alpha Kappa Alpha Sororities, Epsilon Pi Omega chapters, and we welcome you to this part 2 of our event this evening. We have important information to share with you. And thank you for those of you who are returning this evening. We appreciate you joining us. This is a community service that we are doing on behalf of our community. And this evening, you will be learning from many experts around estate planning, something that we all must learn about and know about. And this is a part of our initiative to basically develop our economic legacy, protect our economic legacy. So this evening, the presenters we're going to hear from are the faces that you see before you on the screen. We are going to hear from Miss Elizabeth Gill, Esquire, MSW. We're going to hear from Miss Patricia Cooper, Esquire, lead attorney. We're going to hear from Miss Vivia Joseph, Esquire, solo practitioner. And we are also going to hear from, we hope he will be joining us shortly, Mr. Ferrance G. Lalonde, Esquire, also solo practitioner. And so without further ado, we are going to see our panelists on the screen now. And we're going to, let me introduce to you the person who has been so very, very kind to coordinate all of this mastery before you this evening, before all of us. And that is Miss Elizabeth Gill, who has been doing this and has had the support of Miss Patricia Cooper. But Miss Elizabeth Gill is going to take it away at this time and take us right into what we are here for this evening.
Good evening all, and welcome and thank you for participating with us. We really believe we are out in the community and we see some of the things that happens with a person's estate or lack thereof. And it's really heartbreaking to see how money is lost in our community due to the fact that we just don't take the time to investigate what is needed to be done in order to preserve our assets and transfer them to the next generation, or if that is not your desire, to share with whomever you desire. What I have seen is that a lot of the assets sort of evaporate. It's like the wind coming through the cracks in the windows. You feel it, but you don't see it. And that's exactly what's happening in our community. For some reason, there's this prevailing thought that estate planning is like the end of life. And that clearly is not true. What we need to consider is that it's really accumulating, acquiring, and preserving the personal property, financial assets for self-use during your lifetime, and then transferring to whomever you choose at the end of life. Although it's thought of as an end-of-life plan, and estate actually consists of your net worth at any point in time, life or death. That's your estate. But it has a negative connotation to it, and I think it affects our community just a little harder than I've seen in some other communities. I like to say that without regard to age, marital status, or any family ties, our younger generation seem to believe that they don't have to plan, but you do. And when I say younger generation, I really mean anyone who contributes to an IRA that's either through work or just on a personal basis, a 401, any kind of tax deferred plans, any kind of annuities, or just a bank account. You should have a plan as to what would happen to these assets if you do not use them completely during your lifetime. So as Judge Kelly shared in his program a week before last, yeah, I guess it was 2 weeks ago, if you don't have a will, if you don't have a trust, or you don't have beneficiaries designated on certain assets, you will end up in surrogate's court. You will require the court's intervention in order that someone can be empowered to handle matters related to your estate. And it could be $20,000 or $20 million. If you don't have someone designated, the court will be involved. And what I often hear is that I don't want to do probate because it costs too much money or it takes too long. Well, you can control that. First of all, the most expensive probate petition is $1,250. A non-probate plan will cost you a lot more than that. And it's a way, again, of wealth slipping through the hands of the persons that you really wanted to have it. So our panel tonight will give an example of ways that we lose wealth without even thinking about it because it's on a daily basis. And they're uniquely qualified to do this because they do this every single day. So I'm thinking such as a simple hospitalization and how that can consume assets that we never even thought of until you realize, oh, I might need nursing home care. And then there's this big jump of what am I going to do to protect the asset? There is a point where we can't do as much as we would like to do, depending on the situation. There are some basic planning documents that we talk about, will or trust. It depends on what your assets are, will dictate what works best for you. We need a healthcare proxy, a power of attorney, a written disposition as to who will handle your remains at your death. And this is something we don't generally think of, but at some point, so we all live out, or not we all, but let's just say I outlived my relatives. Well, but I still have in mind what I would like to do as my final for my final rights, but I haven't designated anyone. So there's an opportunity to do that through our public health law. A guardian of a person and your property. Vivia Joseph is truly the expert in this area. But one thing that we don't think of is second marriages. Second marriages are very important. I have seen more fights than a little bit about children from the first marriage being left out of assets that mom or dad accumulated during the first marriage, but it is the second marriage where the surviving spouse, be it male or female, came into those assets. Second marriages, planning for a second marriage is very important when you have children and you have assets that you want children of your first marriage to share in, at least share in, if not the entire thing. So a premarital agreement is one way that you can account for that. And we have some basic planning tools to get there. We have children, we need to think of 529 plans. We need to think of IRAs, life insurance, long-term care insurance for that unexpected, unanticipated stay, perhaps in a nursing home that you're not using your basic assets for. A Medicaid asset protection trust, pre-need accounts, pre-need accounts. My grandmother, I remember her saying, this insurance policy is for my burial. That doesn't work anymore. First of all, if you leave a beneficiary on your insurance policy, I don't care who it is, it's their policy. And they have to agree to assign it to the funeral home. So we're now asking that to think in terms of perhaps establishing your own pre-needs accounts. But I think you'll enjoy the example that the panel has put together to take you through some of the things that occur on a daily basis. And I think you will find that if it doesn't affect you, you might know someone who does. And before I hand it off to Vivian Joseph, who's going to start us off, I am telling again all of our participants who may be single that this is equally as important for you to plan as well as if you may be married with a family. So I thank you for listening to me, and I thank you for participating. And I hope that you will get at least one thing that you could walk away with that would be helpful. After the panel, we'll take questions. I have not seen Ron Leland's name show up yet, but if he's here, for those who know,
He's here, Elizabeth. He's here.
Okay, I'm sorry, Ron, I'm not seeing you, but he's going to talk about reverse mortgages, which our community has been sort of plagued with and sold on without the basic understanding of how that affects your planning for your family in the future. So we think we've got a great number of topics for you and a little fun with the red Maserati car. So on that note, I thank you again, and I'm turning it over to Vivian Joseph.
Great. Great. Thank you, Elizabeth. It's my pleasure to be here with you all this evening. Elizabeth and I have been, and Ron and Patricia has now joined us. We've been doing this forever. We actually do one or two every year for quite a few years, just going to churches and helping the our elected officials to make sure that we try to show our, teach and impress on our community the importance of what we're discussing this evening. So again, thank you all for joining. And may I just have, I'm going to switch over to the slides. May I have the first slide, please? Okay, so we do have a disclaimer on the screen, which I just want to read, because we do have a fictitious fact pattern that we're going to be sharing that covers all the areas that we're discussing this evening. So the materials shared during this presentation are for informational purposes only and not for the purpose of providing legal advice. You should contact your own attorney to obtain advice with respect to any specific concern, issue, or problem. Further, the opinions expressed at or through this presentation are the opinions of the individual presenters and may not reflect the opinions of their associated firms or any individual attorney. Thank you. On the next slide, please. Okay, so this is our estate situation, which we're presenting. And I'm going to read it through, and then I will be discussing guardianship. Ron will be discussing the reverse mortgage situation. Elizabeth will go a little more into the wills, and Patricia will be discussing the Medicaid part of this fact pattern. As a result of being hit by a truck, Blackshare a 75-year-old, was hospitalized with serious life-threatening injuries. He was placed on a ventilator and later discharged to a skilled facility for long-term care. Blackshear was not able to communicate with anyone. The facility needed to apply for Medicaid, but Blackshear did not have a power of attorney or a healthcare agent. A month after being admitted to the facility, Blackshear died. He had no will. He was survived by a wife, a 13-year-old daughter, a 32-year-old son from a previous marriage, and one non-marital developmentally disabled child who is a Medicaid recipient. His estate consists of a house with a reverse mortgage in Southeast Queens County in Blackshear's name only, a claim filed with the court that his death was wrongfully caused, a $65,000 bank account in his name only, and a little red $50,000 Maserati Blackshear promised to give to his childhood friend, Frank, who died suddenly after Blackshear. Shortly after Frank's death, Frank's son demanded the car. Also, shortly after his death, Blackshear's wife was contacted by quote unquote investor seeking to purchase the house, all cash for a great price. Wife expressed interest in selling the house to investor, but son objected that house was worth much more than the offered price, and after the mortgage was paid, there would be little left for the family. Wife applies to the court to be appointed to serve as the administrator of her husband's estate. Son objects to her being appointed because he says house is worth twice what investor offered, that wife is being taken advantage of because she knows nothing about the value of real estate in Southeast Queens. Further, based on payoff for the mortgage, only wife will benefit from whatever little monies are left over if she sells to investor. Okay, so we're first gonna talk about guardianship. As you note from our fact pattern, Blackshear had this horrible accident and he ended up at a skilled facility for long-term care, which means that even if he hadn't died a month later, based on the injuries he had, he would have pretty much been in the facility permanently. The facility needs to submit a Medicaid application for him, but he had no healthcare agent and no power of attorney. Two items that will be discussed later on. I'm sorry. His wife is not on his bank account. She cannot access funds to pay for his care. She cannot access funds to pay any bills on his behalf. And given the extent of his injuries, we know that $65,000 will not go a long way. So let's review one of the legal areas which New York State has developed for individuals who unfortunately find themselves in the position that Blackshear and his family found themselves in. And that area is the area of guardianship. An Article 81 guardian, which is the type of guardianship proceeding that the wife would have to seek for Blackshear prior to his demise. That Article 81 is brought in the Supreme Court and is generally for individuals who lack mental capacity to execute advance directives or whose advance directives are not comprehensive. So in our situation, Blackshear did not execute a power of attorney and he did not execute a healthcare proxy. So the only option available to Mrs. Blackshear would be for her to file an application to the court to seek the appointment of a guardian over her husband under Article 81 of the Mental Hygiene Law. This process is a judicial determination and it's based on clear and convincing evidence that the individual is incapacitated. So in Blackshear's position, where he's unable to communicate with anyone, the court would not have a high burden to reach in terms of making a determination that Blackshear is indeed incapacitated. One of the issues with Blackshear not having prepared either a power of attorney or a healthcare proxy is that his wife can seek the appointment as guardian. His son, the 32-year-old who is objecting to his wife selling the property to the investor, he is on equal footing with her to seek the appointment of a guardian. And if there is confusion in the family regarding who should serve, we also have the facility that can make that application to the court. So the law allows anyone to file a petition for the appointment of a guardian. And in many instances, when the family, they're unable to decide or to work in the interest of the incapacitated person, the facility will contact their attorneys and they will make that application to the court. And so everybody will end up in court, and then the fight begins on who should be appointed. And when that fight begins, then the judge will make that decision. So judges generally seek to appoint private attorneys or community organizations to serve as guardians, but the judges usually prefer family members who are familiar with the incapacitated person to serve. If the family members cannot agree, then that Part 36 list, where many of us attorneys have signed on to those private attorneys who have indicated to the court that they're willing to serve as a guardian, the court will then just pick a name from that list, and that's the person who the court will appoint as the guardian for Blackshear. Now, in order for the application to go forward, as I said, the facility can do the application, any of the family members, a friend can do it, a neighbor can do it. As long as that person is over 18 years of age, they can make that application to the court. Once that application is filed with the court, then the court, the person who files the application is called the petitioner. And the petitioner will then lay out in their papers why a guardian should be appointed for Blackshear. When the petition is filed with the court, the first person who gets appointed in a guardianship proceeding is called a court evaluator. And the court evaluator is generally called the ears and eyes of the court, meaning that the court is sitting inside the courthouse. The evaluator is able to go outside and do all the investigation that's required in order to inform the court as to whether or not a guardian should be appointed in this situation. The court evaluator is expected to perform an independent investigation, which means that despite the in-family fighting that may be ongoing, that court evaluator has to speak to everyone in the family who is connected and who they can reach with respect to Blackshear, so they can get an understanding of the family dynamics and what the underlying issues may be, why the family couldn't decide without the petition being brought to the court. The evaluator is must read the petition in order to understand what the issues are. The court evaluator must meet with the family members, speak to the neighbors, speak to friends, and they must conduct, he or she must conduct a thorough investigation. Once they have conducted that investigation, they then have to prepare a written report, which is filed with the court. And in that report, the court evaluator makes the recommendations as to who should be appointed the guardian. One, whether a guardian is appointed, and if so, should it be wife, should it be son, should it be an independent guardian? At the return date, the court evaluator actually testifies on the oath as to the findings made with respect to the Blackshear family. And from the written report, the testimony of the court evaluator, or the testimony that the court will take at the hearing, the court will then make a determination whether a guardian should be appointed and who will serve in that capacity. And in many instances, because of the immediate need to have a guardian appointed, the court usually makes that decision from the bench. So the court will also conference the case if there are different attorneys involved, to see whether it can be settled and everybody can agree on the guardian. If you can't, then the court definitely makes that decision. Once the court hearing is over, the judge will then issue an order and judgment in which the court appoints the guardian, and that guardian may be a guardian serving in both capacities. Guardian of person is one capacity, guardian of property is one capacity. So sometimes the court will split the responsibilities. The court may decide, okay, I'll appoint a guardian of person from the family, and I will appoint a guardian of property from the Part 36 list. And because sometimes, depending on the dynamics, the court wants to ensure that the whatever assets the incapacitated person has, those assets will be protected. And before the person is called an incapacitated person, when the petition is filed, the individual is alleged to be incapacitated. So you don't go into court and say, oh, he's incapacitated. No, he's alleged to be incapacitated. And based on the evidence and testimony that the court receives, the court will then determine that the person is incapacitated. If Blackshear had not been in the position where he was no longer able to communicate and he could consent to a guardian, then the court would determine him to be a person in need of a guardian, so that he actually gets a say in, some of the decision making that happens for him. Some examples of the personal needs guardian that they would be required to do will include making healthcare decisions for the incapacitated person, deciding where the person should live, applying for government or private benefits on behalf of the person. So in this case, there was an issue of Medicaid application. The guardian of person would be empowered under the order and judgment to make the application for government or private benefits on behalf of the incapacitated person, also known as the ward. And the guardian of person will also have the ability to access confidential records if such is needed for making decisions on behalf of her ward, his or her ward. With respect to property management, the powers that a property management guardian is given would include paying bills, organizing assets, entering into contracts, making certain gifts on behalf of the incapacitated person. And in this situation where there is an attempt to get Mr. Blackshear qualified for Medicaid, the guardian may be empowered, and he's already 75, so he would not be eligible for a supplemental needs trust, but he would be eligible for a pool trust. So the court could also expand the powers and give the guardian of property permission to open a pools trust account for the incapacitated person, whereby the excess income that that person has would be placed in the pool trust in order to make them Medicaid eligible. And you'll hear some more about the Medicaid application a little later on. In addition to the appointment of the guardian, the court also appoints a court examiner. And the court examiner, also selected from the Part 36 list which the court maintains, is responsible for examining the records and reports that the guardian has to file annually. So under the Article 81 mental hygiene law, the individual who is appointed as guardian for Blackshear would, if you're a guardian of person, you have to file a report annually. If you're a guardian of property, you have to file a report annually. And that report for the personal needs guardian, they're just updating the court on this is where things are. The social setting is good for the incapacitated person. They're getting whatever activities in the facility. They're seen regularly by a doctor, and all their needs are being met. If they're living in the community, the guardian of person also has to report to the court as to the status of their ward living in the community, and that all steps have been taken to ensure that the ward is safe. The court examiner, so the court examiner will examine all the reports that are filed prior to the court looking at the reports. And the court examiner will bring any proceedings if they feel that this guardian is not doing what they're supposed to do for the benefit of Blackshear. The court examiner can do a motion to remove that guardian and ask for a substitute guardian. If the fighting continues in family and things are just not improving, the court examiner has a responsibility to bring certain of those issues to the court. So with respect to Blackshear, he unfortunately passed a month later. So there would not have been enough time to get his Medicaid application in place. And so I think I will turn this over to, who's going to speak next? Is that going to be you, Elizabeth, or Ron?
Patricia. It's going to Patricia. And I just wanted to say, any questions will be taken at the end, and please feel free to put them in the chat. We'll hang around to answer questions for as long as you like. Not as long as you like.
As long as we can. So, okay, perfect. So I'm going to turn it over to Patricia, and she will pick up from there. And we'll come back. If there's anything missing, we'll certainly cover all of that before the evening is out.
Excellent. Thank you so much for that comprehensive overview of guardianship. As you all learned, I'm Patricia Cooper. I'm an attorney in estates planning. And as you learned, an Article 81 proceeding can take a really long time. On a good day, it might take just a little over a month. But typically, as in the case as Vivian described, by the time they would have been done with that entire application, unfortunately, Blackshear would have passed away. So I'm going to talk a little bit about some of the planning documents that you can have so that if you ended up in Blackshear's situation, you'd be well covered. So when we think about estate planning, there are really three elements. It's really who's in control, who gets the benefit, and when does that plan go into effect. That plan can go into effect when you're alive and well. It can go into effect when God forbid, if you're incapacitated. It can also go into effect, God forbid, you pass on. And it's really important that you realize that there are a number of planning documents that can help you in that process. So first, Vivia alluded to this, and that's a healthcare proxy, right? So a healthcare proxy is, the healthcare proxy law allows a person to appoint someone he or she trusts, for example, a family member or close friend, to serve as an agent to make healthcare decisions in the event that a person loses the ability to make decisions for him or herself. Hospitals, doctors, and other healthcare providers must follow the agent's decisions as if he or she was the patient. However, the agent's decision-making ability is limited to the powers granted within the document. It's very important that you understand that a healthcare proxy goes into effect when the person has become incapacitated or if the person is unable to consent. And that person would, the healthcare agent would then be authorized to make those healthcare decisions. Oftentimes in hospitals, I hear people saying things like, oh, my 85-year-old mother is in the hospital and I'm her healthcare proxy, so therefore I can make decisions for her. Well, if your 85-year-old family member is in the hospital, but they're alert and oriented, they can speak, they can make decisions for themselves, well, then that healthcare proxy doesn't go into effect. When we think about Blackshear was now in a position where he was in a ventilator. He was on a ventilator. He had this serious life-threatening event. As a result of that, he had no one really to make a decision for him. Now, New York State does have a law called under the Healthcare Decision Act that does allow some decisions to be made, and there's a process in which a provider would be able to look at the elements of that law to determine who would be the person who would be able to make decisions. However, your healthcare proxy is really the document that you need to ensure that those decisions are being made on your behalf. And then another document that we talked about related to Blackshear is the fact that is a power of attorney. As Vivia alluded to, We have Blackshare in a nursing home, and he wants to apply for Medicaid. And I'm going to talk a little bit about Medicaid also. But even in order for you to even apply, you need someone to apply on your behalf. So I will tell you that if a nursing home is the one who's doing it, making that application on your behalf, they may not be as concerned about their own asset, about your assets, right? They just want to get paid. That's why the nursing home is applying on your behalf, so that they can secure the funds to pay for the stay, and it may not have your best interest in mind. So let's talk again about the power of attorney. So it's an important document that gives the person designated an agent broad powers to handle property during the person's lifetime, which may include powers to mortgage, sell, or otherwise dispose of real or personal property, as well as handle banking and other important financial matters. Depending on the decision, these powers could continue to exist even after a person becomes disabled or incompetent. Once a power of attorney is assigned, it can be used by an agent, so it is essential for the agent to be someone you trust. In many ways, some people have called it a blank check, because if it's not done correctly and you don't have the right provisions in place, then what can happen? A person has full control over your finances. It goes into effect at the time in which it's fully executed, so that you really want to make sure that you're protecting that document so that that way it doesn't go into the wrong hands. So looking at Blackshare, what could the power of attorney have done if he had had the power of attorney in place? Well, he could have applied, the agent could have applied for Medicaid on the person's, on Blackshare's behalf. It could have effectuated a financial plan. You know that in the example that we shared, there was a house involved. There could have been, the house could have been retitled. There are a number of things that could have been done had a power of attorney been in place, but unfortunately one was not. And also the power of attorney could also preserve assets in ways that we were unable to do for Blackshare, unfortunately. We talked a little bit about Medicaid. What is Medicaid, right? Some people think, oh, I don't want Medicaid because Medicaid is, it's only for poor people. Well, ask your family members if they would rather, or at least people, your beneficiaries, maybe if you have children, maybe your children, ask your children how they feel about Medicaid, given the fact that if you didn't have Medicaid, then everything you've been living for, everything you've been working hard for, it now goes to the government because it's going to now pay for all of your care. Meanwhile, the kids are like, well, hey, what about me? Well, unfortunately, if you don't create your plan and you don't make your and plan things out quite the right way, Uncle Sam, New York State, people can take your resources. And so Medicaid is actually designed, we worked hard, we pay into Medicaid so that way it can be used. And so Medicaid is a state and federally funded healthcare program for typically low income individuals within certain eligibility groups. People included are pregnant women, children, and individuals who are disabled. Based on the facts here, Blackshare needed to apply for Medicaid. Had he had a power of attorney, his wife could have done so on his behalf. She could have also, again, as I alluded to earlier, worked on doing some other asset protection strategies so that way their assets would have been protected. Now, in the case with Blackshare and the fact that the Medicaid application, they would have had to go to guardianship. Let's just say she had a power of attorney. She had a power of attorney and she went ahead and she applied for Medicaid. Now, of course, 75 is still young. So no one, I'm sure, would have anticipated that Blackshare would have been ill, would have sustained the injuries that he had sustained, and ultimately leading him to be on a ventilator, as well as being in a nursing home. That would not have been anticipated. However, there are strategies that could have been taken to ensure that the assets were protected, including in the case of Blackshare, what could have been done is, well, if the power of attorney was there, the house could have been retitled, right? if the house was retitled, then there was a possibility that that the nursing home would not be able to attach to the assets. When you think about Blackshear, and if he did have Medicaid, then because the house was in Blackshear's name, even at the time of his death, New York State can sometimes, or at least Medicaid would try to recoup those assets, and they might have attached to the home and try to recoup some of the money spent while he was in the nursing home. So again, really, really important. There are a number of really great strategies that one can use in order to protect assets. So we know that unfortunately Blackshear didn't make it, and Blackshear didn't have a will. So what is the last will and testament? It's a legal document that, among other things, disposes of property, both real and personal, according to the wishes of the testator or the person making the will. It states your wishes regarding a guardian for your children if anything should happen. The person designated in the will does not automatically have legal authority to act as a guardian for the children. That person will have to go to court for approval. But in order for your will to have an effect, it must be probated. Probate is the legal process for proving the validity of the will, determining beneficiaries, paying creditors, and distributing assets. So when if one dies with a will, what ends up happening, you have to go to probate court, you go to the surrogate's court, and when you go to the surrogate's court, they have to go through this process, and then your will gets admitted into the court, and it becomes a public document. So you may have heard people talk about trusts. So a trust is a legal arrangement through which assets are held for one or more beneficiaries. Individuals may be designated as the trustee or trustees to manage the assets according to the terms described in the trust document. The trust document will then provide specific details for how the assets in the trust document are managed and how and under what circumstances they should be distributed. Depending on the type, trust may help you avoid probate. Additionally, depending on the type of trust, you might even be able to secure assets. And I know a concern that people have is, oh, well, do I have to, I have this house. How long does it take before I can have the house in my name? After my loved one has passed away, my loved one put the house in a will. And so I just have to wait. Well, sometimes it can take several months up to, in some cases, even a year if a will is contested. So you would have to wait a really long time before you got the house. But if that house was in a trust, for example, at the time of passing, then it allows for an easier opportunity for you to have access to that house. All right. So then we're looking at this example, right? We have this $50,000 Blackshear Maserati that Blackshear promised to give to his friend Frank. So in essence, it's a promised gift, right? So one would say, is that a gift? Well, I don't know. Let's see what the law says. So in order for a gift to be complete, you need to have a donative intent. That means the person really wanted to make sure that you got this gift. You have to have the gift delivered, and then you have to have acceptance. So given the fact that we see that Frank demanded the gift, right? We don't know, Frank had passed away, so Frank's son had demanded the car. If the car was in Frank's possession, one could argue that the gift had been delivered. But in this case, based on this fact pattern, there's no proof that it had been given, and there's also no proof that Blackshear really promised this car over to his friend Frank. So there are a number of things here that we would have needed to have fleshed out. And certainly, if you want to give your friend a Maserati, if you have a Maserati and you'd like a friend to give it to, I'm available. But you want to make sure that you have all the elements of a gift at the time in which you want to give that gift. So I've spoken quite a bit. We could go on and on and on for a long period of time. But at this time, we're going to talk a little bit about foreclosures and mortgages, and I'm going to turn it over to my esteemed colleague, Ron.
Okay, thank you, Patricia. And thanks for allowing me to be on the program. Can you hear me?
Yes.
Oh, okay, all right, okay. Job well done by all my colleagues so far. I hope I can live up to what they have done so far. So as Patricia pointed out, I'm going to talk about reverse mortgages and foreclosure. And one of the reasons that this is important is for many of us, the biggest asset that we have is our home. If we've purchased a home, that's usually the biggest asset. Not all the time, obviously, but sometimes it is. And so we want to protect that asset, because if we don't protect it, it's in danger of being lost at a time when we're going to need it, or at a time when we want to pass it on to our heirs. So let's start with reverse mortgages. And I also have to point out the fact that not only in relationship to it being the biggest asset, but it's important to us because we've raised our families there. Oftentimes, we may have lived there as children ourselves. We may have raised our children. We may have raised our grandchildren there. We've had many events in those homes. So not only is it important financially, it's important spiritually as well, and certainly emotionally. A lot goes on with the houses that we own. So what is a reverse mortgage? As the name suggests, a reverse mortgage is reverse of what a traditional mortgage is. That is, when we go to buy our house, we buy it, we try to secure a mortgage, which is evidence that we borrowed the money, and then we live in that house, but we have to pay that money back that we borrowed from the lender. Typically, it's a 30-year mortgage, but it could be more than 30 or it could be less than 30, but typically it's 30 years. But in a reverse mortgage, it's just the opposite. We borrow off of the equity we have in our homes. So it's usually utilized by folks who have either paid off their entire mortgage or have a lot of equity in their house. So therefore, there is sufficient equity for them to borrow against it. But they have to pay that money back, and that money gets paid back at the death of the homeowner who was named on the reverse mortgage, or the several homeowners, because it could be more than one, it could be more than two homeowners whose names are signatures on the reverse mortgage. But it's payable at the time that the last homeowner passes, or the last homeowner leaves the house, never going to return, or assumed never going to return. Then the mortgage becomes due. One of the problems with a reverse mortgage is that you have to be able to pay that money, well, not to pay it back at that particular time, but it's eating up the equity in your house. Every month that you have a reverse mortgage, the debt that's owed on that debt increases every month. And so therefore, the equity that you may have had in that house that you want to leave to children or grandchildren or friends, whatever, grows tremendously because of the fees that are associated with reverse mortgages, because of the interest rate. And reverse mortgages are intended, all the people involved in presenting a reverse mortgage are making money. So it's a lot of fees that go along with a reverse mortgage. In order to get a reverse mortgage, you usually have to be at least 62 years of age. And again, there could be multiple homeowners involved. You have to have sufficient equity in your house to do so. One of the good things about a reverse mortgage is oftentimes they don't require you to have great credit rating or to have a high credit rating. So, but what happens is that that requirement isn't necessary because their collateral on that loan is your house. So if you do not pay the requirements of your reverse mortgage, they can foreclose, which includes the fact that, which is again different from a traditional mortgage, rather the lender pays the taxes and insurance on your behalf through your monthly mortgage payment in most instances. So your taxes and insurance and the interest on your loan and the principal on your loan gets paid through your monthly payment. However, in a reverse mortgage, that obligation for taxes and insurance is on you. That you have to pay the taxes, and in New York, the taxes are generally paid quarterly, every 3 months. You pay it monthly when you're paying a traditional mortgage. Your insurance is paid usually once a year, but monthly through your mortgage payment. So again, the obligations are there that you're not used to. So when you take out a reverse mortgage and you don't remember the fact that your taxes are due every 3 months and that your insurance is due, and those things are not paid, the mortgage lender on the reverse mortgage can foreclose on the property. And one other requirement is the fact that you also have to maintain the condition of the property. That's your responsibility as well. And as a matter of fact, one of the conditions to getting a reverse mortgage is your house has to be in good physical shape. And if it's not, you won't be eligible to get that reverse mortgage also. So that's an additional thing you have to know in advance. Now, usually the amount of loan that you can get on your equity is usually somewhere between 60 and 70% of the equity in your property. So if the property, for example, is worth $500,000 and you can get 60% of that, you can actually borrow $300,000, which again would be payable back when the house is sold. Now, you can get that money in basically 4 different ways. You can get that money in a lump sum. You can get that money in equal monthly payments every month. You can get that in a home equity line of credit. In other words, so that you can have credit available to you and you can spend up to that amount at any point in time. So you don't have to spend it all at once. It's just sitting there ready for your use, whatever that amount is that you borrow. Also, a reverse mortgage can do any of combination of those 3 ways of you receiving the money, any or all of those other 3. The proceeds from that you receive from on a reverse mortgage are tax-free because it's not considered income. It's considered a loan, so you're borrowing that money. Only time you get credit for the interest that you pay is at the end when the house is sold, and you can get credit on your tax return for the accumulated interest that you paid, or your heirs, you paid, but the heirs get the benefit of that taxes at that particular point in time. So those are some of the positives and the negatives of the reverse mortgage, but additional drawbacks are, again, as I pointed out, the fees keep building up there tremendously, and they're really eating up the equity that you have in your home. Also, most of the interest rates, when you have a traditional mortgage, interest rate may range from anywhere to 4%, 5%, 6%, but most home loans, it's a set mortgage rate. There are variable ones, but most of them are set traditionally. However, in a reverse mortgage, they're variable. So if interest goes up, the eating up of your equity in your house goes up as well. So it just adds up on all the monies that you're paying on a reverse mortgage. And all that, even if you're leaving your house to someone else, they're going to have to pay that off if they're eligible to do so. It also, as mentioned, it was spoken earlier about Medicaid, et cetera, et cetera. A reverse mortgage doesn't affect your Social Security income or your Medicare, but it can affect your Medicaid. So that's a case-by-case basis, but it does have to be explored before you think about getting a reverse mortgage. So all sum and substance, is a reverse mortgage a good thing or a bad thing? I do think that it's particular to each individual situation. There are definitely some negative things, but sometimes it works for people. For example, if you have a big family, you want to make sure that house goes to your family, probably you don't want to do a reverse mortgage. However, if you have no one you really want to leave your house to and you're short on money, because usually the importance or the usefulness of a reverse mortgage is that you're unable to pay your regular bills on a monthly basis. That's the reason why most people get a reverse mortgage. But is it going to upset your life's plans of leaving your house to your family? In the fact pattern, it expresses the fact that there was a reverse mortgage on Blackshear's home. Now, and the fact that the house was only in his name means that the house is now subject to what the reverse mortgage lender wants to do, because they can call the mortgage being due because the only homeowner died, and therefore whatever the debt is on the house is subject to be paid and has to be paid. So that's a dilemma. In this instance, though, the family can do one of two things. They can try to sell the house and try to sell it for more money than is owed on the property, so therefore they would keep the difference. So if the balance of the reverse mortgages was $350,000, and of all the costs and all the fees, and the house sold for $500,000, they could keep the $150,000 balance. However, if they wanted to, other than that, they would have to come up with that $350,000 to pay the existing mortgage in order to keep the house. For most families, that would be extremely difficult to do, but that would be their choices in that particular fact pattern. So I think it's paramount that anybody that's considering a reverse mortgage do their due diligence and make sure it's going to be fitting for them, because you see the advertisements on the television, all these famous people putting forth the importance of or the value of doing a reverse mortgage. They're getting paid. All the people in the line that sign you up and put you up, they're all getting paid. And the way they're getting paid is because these companies make a lot of money off of that. So again, if it's a tool that can be used, and if you have to bang a nail into a piece of wood, most people would use a hammer to do that. So that tool would work. But if you pick up a pair of pliers or a wrench to bang that nail into the wood, that's not a fitting tool for that task. So you have to make sure what you're doing is going to fit for you and not a fit for somebody else. And all these artists with that, those con artists, because there's a lot of them going around. Okay. And finally, I'm going to speak real quick on foreclosures because I know it's getting real late. So foreclosures are related to a reverse mortgage as well, because the lender is going to foreclose. Now, other situations where we don't have a reverse mortgage and we not happen to get, but we get a letter in the mail one day saying the lender is threatening to foreclose, because usually the reason is you haven't been making your mortgage payments. And they'll usually send you a letter the first month, and then the letter for the second month is a little bit different, and the one on the third one is going to be more threatening. So we have to figure out what to do. And the worst thing that we can do is what people often do is they ignore, they see the first letter and they don't even open the envelope on the next letter. And that's the biggest mistake you can make. you have to respond. Foreclosed lenders actually don't want to foreclose. They prefer not to. It's easier for them not to. Okay, because oftentimes, even if they foreclose, sometimes they risk not getting all the money that they were owed. So you can speak to them on your own. And when you get that letter, explain your situation, because people get in financial difficulty for all reasons. Sometimes, many we don't have control over. A family member dies, a family member is disabled, the storm damages the house and you don't have the money to pay for it. Whatever case, so there are reasons why. So it's oftentimes you can negotiate directly with the lender to either put them back money that you owe and restructure the loan and put it at the end of the loan, the existing mortgage, or you can extend the term of the mortgage. Say you have 20 years left on the mortgage, of 30-year mortgage, you could restructure it so you get an additional 10 years back, make it 30 to help reduce the monthly payments. And maybe at that rate, you can make the monthly payments, or a combination of those two, put it on the back end and reduce the monthly payments. So there's often many ways to do that directly with the lender. Often right now, and particularly with COVID, there's, in addition to the lender, there's the government allocated billions of dollars to help homeowners in trouble. And that money has been passed to the states. So through directly to the US Treasury, or through the, probably quicker with the New York State, you can apply to get help to pay your mortgage. People should do that. It's probably the cheapest way to do it. If you're eligible to do it, you should make that attempt. Third, there's also organizations that help homeowners fight foreclosure. Community groups. There's one called the New York City, Center for New York City Neighborhoods. The telephone number is 646-786-0888. That's 646-786-0888. They will also help out in relationship to fighting foreclosure. But one of the ones that I also recommend, and certainly many of my fellow panelists on this program can help with as well as myself, we can do that as well. And that is to contact a lawyer that can help you out. And this is particularly important if the foreclosing bank has already started legal proceedings, and that is filed papers to start the foreclosure. You definitely want to make sure you contact an attorney or one of these other organizations, that whoever is going to help you and that can help you, that's what you should do in order to save your house. Because all problems, it's my belief that all problems have solutions. Foreclosures have multiple solutions that could be done. It's creativity. It involves knowledge and information to help you do it. But don't waste time. Do it as soon as you can. Of course, the sooner you intervene with correcting the situation, the better it would be for you and your ability to stop the foreclosure. So with that, I'll turn it back over to.
Okay, thank you.
Did I mention? Oh, I mentioned about Blackshear, right? I did.
Yes.
On the reverse mortgage.
Thank you, Ron. And just to round out, you notice on the fact pattern, we talked about the fact that there was no will. So we know from Judge Kelly last week, this would entail a family person being appointed to handle the legal affairs of Blackshear. You also notice that the wife and the son were contending as to who should be appointed, because Investor was making this great offer. Again, watch out for the great offers. Everything that glitters is not gold. A lot of homes have been just weaseled away from the members of the community with the term all cash, all cash, all cash. And somehow that catches our ears. It's like they're going to come with the suitcase with the money in it. That's not going to happen. The other thing is whatever you're offered, you can be assured that it's worth probably 1.5 times of what they're offering you. But that's another way that the assets and wealth seeps out of families and communities. You heard Vivia say that with guardianship proceeding, a number of persons can apply within the family, or it could be an outside court-appointed person. However, in a court proceeding, when there is an administrator, the person dies intestate without a will, and there is a hierarchy. The wife trumps the son. So the fact that he has more knowledge about investments and property, unless they can agree and she defers to him, the wife would have the first right under the law to represent her husband's estate. What Ron was talking about with the reverse mortgage, any number of individuals have said they wanted to leave that house for the benefit of their generally children. It's important to know that with a reverse mortgage and the way that the interest accumulates, you have lost equity in the property that would have gone down to the next generation, or as you so choose. Again, an evaporation of money out of your estate for your family or for whomever you choose. I just caution, if you know anyone who is approached by an investor to give you a good deal, if you're not sure, speak to someone about it, because they capitalize on the fact for some reason that maybe we don't do our due diligence and we hear a number and we think that it's a great number, but we haven't found out what the value of the property is. A lot of wealth is lost in Southeast Queens. So one last thing, there was a child, a non-marital, developmentally disabled child who was a Medicaid recipient. Be aware that if you're making a will, that if you have a child or a person who is a Medicaid recipient, you want to be careful as to how you construct that gift to them, because it could affect their benefits. And that's very, very important. That might be an area where a trust would be considered for someone in that situation. The fact that there was a 32-year-old son from a previous marriage is a non-issue. He's the child of his father. He's entitled to take. But it goes back again to second marriages and children of second marriages and how we prepare for them to share in our estate. The little red $50,000 Maserati car, it doesn't go to the friend unless, as Patricia had said, you can prove that it was a completed gift at the time. However, that would be an estate asset of the Black share. So that $65,000 car, $50,000 car could be sold, and the money's put into the estate. The same thing with the bank account. And the wrongful death claim doesn't come up a lot, but wrongful death claims, if no matter what the amount of money is, is shared according to a formula set forth in the law. So there's a surviving spouse and children. There's a specific formula as to how that would be shared. Now that's a way that for someone who's on Medicaid would be entitled to a share in that instance where, again, you'd have to look back to. So with that, we'd like to answer any questions that you have, based on the example presented, or as you heard something, it brought something to your mind that you would like to know about. So we're opening it up if there are any questions in the chat.
Thank you. Thank you so much to each of you for this wonderful, your wonderful presentation. And so there are a few questions in the chat, and I will start with the first one. Can a family member take out a mortgage to pay off the reverse mortgage and pay off the reverse mortgage company?
Sounds like Ron.
Yes.
Ron needs to be unmuted.
Okay, I just unmuted myself. Can you hear me?
Yes.
Okay. Okay, a good question. Well, a family member can, in the fact pattern that we have here, it'd be probably a little confusion about who would do it. But if it was clearly, say, one distributee of the deceased person, it would be easier to do that. And yes, if they were able, if they had the credit worthiness to be able to do that, and to borrow enough to pay off what's owed to the reverse mortgage lender. So they have a possibility to do that. So it's the same thing when your house is in foreclosure. Before that house is sold in a foreclosure, if you can sell the house as the owner, you can sell it and pay off. If you get enough money, you're gonna have to pay it off at the closing to pay off the loan that's on the house, whether it's a reverse mortgage or a traditional mortgage. So a family member can do that. They have to have the ability to do that, like you're getting any mortgage. If you don't have the ability, credit worthiness, you're not gonna be able to borrow the money. Sometimes multiple family members may be able to get into it. And it may cost them, because of the emotional attachment to the house, it may cost them more money than the house is worth to do that. But if they can get a loan, they have a right to do that if they're distributees of the deceased person. So I hope I answered the
Yeah, and
question.
I'll just add on to that too, Ron, that if the guardianship process had gone through and a guardian was appointed, and let's say the family members wanted to take over and pay off that reverse mortgage because the wife is still living there, the minor child is still living there, then they would simply just, or I will say simply, but they would make an application to the court for permission to do that. So there are ways to resolve the reverse mortgage situation before death, because after death, then, it spirals a little more out of control, I think, than before.
Okay, thank you. To the person who asked that question, does that answer your question?
Yes, it does. Thank you.
Thank you. Okay, the next question for the panel. Does the wife trumps the son scenario apply to new marriages? For example, what if the couple are newlyweds?
And there's the son?
They're using your scenario. They said, does the wife trumps the son scenario apply to new marriages?
It applies to the surviving spouse, whether it's a new marriage or an old marriage. I just said, if there's a son, it sounds like maybe this is a second marriage. I am talking about to the person who raised the question. Were you thinking that this is a second marriage where they were newly married? Because if it's husband and wife who've been married for a while, it's going to be the same thing under the law. The surviving spouse has the first right.
Okay, thank you. I understand.
Okay. Let's see. There is another same person, Miss Reddick. Was Miss Cooper making a point that one should put assets in a trust while they are still able to make decisions in order to avoid probate court or complications?
So the answer is yes, by putting assets in a trust that does help to avoid probate. It also allows for the easier transfer of assets. You don't have to wait as long. I would also like to add with the comment about the wife trumping the son, just keep in mind that if you die without a will, the wife gets, according to New York, if you're in New York, the wife gets the first $50,000 and she gets half of the estate and the other half divided between the kids. So something to keep in mind as well.
Also, along that line, if you die with a will, as one just came into my office where the husband disinherited the wife, that does not happen in New York. You cannot disinherit a spouse. You don't have to give your children anything. You can leave it all to the cats and dogs, but you cannot disinherit your spouse. Your wife is the surviving spouse who received nothing under the will is entitled to a right of election of 1/3.
And it's not automatic on that right of election. You do have to file the
Yes.
necessary application within the court within, what, 7 months of the appointment of the administrator or the
Yeah, it's
executor, but you have to timely file it or you will lose that right.
The
Yes,
other thing for
that's a good point.
And the other thing for people to remember is if you created your documents when you were in your first marriage and then here you are in this second marriage, just make sure that you're constantly looking at your documents. That's so important because life changes. There are people who create documents before they have children. They think they're not having any more children. Then they have other children. And then after that, the new child gets disinherited. So really just make sure you're really looking at your documents regularly.
And one last thing for me on that. New York does not have common law marriage. So just recently, there was a couple together for 40 years. And the surviving partner thought that they were married under New York law, but they were not married. And she could not claim any of his assets. They were all in his name alone. So I just caution you, just to be careful that if you have long-term relationships, you really want to make sure that you've made some plans along those lines.
Right.
Thank you for those responses. Here's another. Can you say something about how life insurance can be used as a tool for financial planning?
Yes, I can. And there will be like a little overview of asset protection that is going to go in the chat that you can download. With life insurance, you can, and not term insurance, you're talking about buying into one of the plans that will give you X dollars to your family on your demise, which then can be used for any number of things. But there are different types of plans, and you have to explore what would be the best plan. Some plans with annuities work well for families where there's a payout to I'm saying the family, but whoever the designated beneficiary would be. And life insurance is one of the things that's not taxable in New York. 529 plans are good for beginning to finance, your children's education.
Thank you. Okay. Would you mind
Thank
expanding?
you so much.
Okay.
Okay. How would you expand on how to leverage trusts and other tools to protect assets as it pertains to long-term care applications and Medicaid?
So one of the things that there are income and asset limitations in Medicaid. And so I will tell you that the income and asset limitation is actually pretty low, right? So if it's a married couple, you have to have you can have up to $16,800. If you both are applying, if you are, there's also, you're allowed to have what they call accountable resource allowance. So there are allowances. However, what the goal is, as I mentioned before, Medicaid is considered for low income individuals. So you need to create a plan to spend down those assets, or at least place those assets in tools that allow it to be protected. It's very fact specific. You have to take a look at your scenario, because sometimes people have money in lots of different places and they think they can qualify for Medicaid, but they really, I mean, you can qualify. The question is whether they'll be able to recoup your assets at the time of passing, because Medicaid wants your money. And so they would rather spend your dollar than its own dollar. So there are a number of tools, but it's very fact specific. I have to understand what your specific scenario is. You have to take a look at all the assets, where all of your money is, or where the family member's money is, and then determine what works best. There are a number of different tools, different kinds of trusts. There's special needs trust, there are pool trusts. There are a number of different tools that you can utilize in order for you to protect those assets and then also to spend down that money. Importantly, if you go ahead and you decide, you go to the nursing home and you say to the nursing home, here I am, I want to qualify for Medicaid. They'll get you to qualify for Medicaid, especially if you have a spouse. You can shift assets to the spouse. There are a number of ways you can do that. But keep in mind that if it's not done correctly, they will take their money back.
Thank you. Thank you. Thank you. Okay. So, does a person have to file a health proxy in addition to the Article 81, or is the health proxy a stipulation within Article 81 guardianship in regards to an elderly person?
Okay, that's a two-part question. I'm going to just scroll up on the chat so I can I can just read that. Okay. Do a person have to file a health proxy in addition to the Article 81? So if a healthcare proxy exists at the time of your filing for the Article 81, and you're appointed the guardian of the incapacitated person, then the powers that you have under the guardianship are usually much broader than what you have in the healthcare proxy. So in many instances, the court will void that healthcare proxy because now you have the requisite authority as the guardian. If the court appoints an independent person to serve as guardian, they will void that health proxy because they don't want conflicts occurring with respect to the care of the incapacitated person. So that if you're the healthcare agent and you're not appointed the guardian, you will not have the authority to make the medical decisions on behalf of the incapacitated person. However, it would be helpful if you work with the individual who is appointed so that they can have an idea what the wishes were of the incapacitated person. One of the things we face as guardians when we're appointed from the Part 36 list is that we don't know what the wishes were prior to the person becoming incapacitated. And so when issues come up in the hospital regarding signing a DNR or similar kind of document, generally the guardian can't sign that document. And so, you know, family members who are familiar with what the wishes are will get upset that, you know, I know that, you know, my dad or my mom or grandma didn't want this or didn't want that, but the guardian wouldn't be in a position to honor those wishes. But if the document was made available to the court prior to or during the proceeding, then it would have some weight in terms of carrying out the wishes of the incapacitated person. And then part 2, or is the health proxy a stipulation? Okay, I think I answered that in the one question. So the healthcare proxy pretty much goes away once the guardian is appointed with the requisite authority to make the medical decisions.
Okay, thank you.
Vivian, I just want to ask you a question as if I was in the audience. And that
Okay.
question is, well, if I have a power of attorney and I have a healthcare proxy, well, do I even need a guardianship proceeding?
You don't. It kind of depends on what you're trying to get done. Because sometimes those documents are not as broad in terms of the powers. And so it would make sense, you know, you come in, you speak to us, we would look at the document, look at the issues as they're presenting themselves, and then it may become necessary to seek that guardianship. You may have a situation of, mom signed this power of attorney with me however long ago, I was added to all the bank accounts, and now here comes brother with a new power of attorney. And of course, the new power of attorney invalidates the prior power of attorney. So now brother has the authority to make the decisions, but brother is actually using that power of attorney to kind of, you know, take money out of the accounts that's not being used for the benefit of mom. In that case, we would say definitely go for guardianship, because the court will void the whatever powers of attorney exists. And so the only person who would have property management powers would be the guardian.
Very helpful. Thank you.
You're welcome.
Will a person still need Medicaid if they have private health insurance once they become elderly?
Private health insurance is very different than long-term care insurance. So I'm not sure if the person means my Blue Cross Blue Shield health insurance typically will not cover long-term care. There is a separate policy that is designed for long-term care in one of the facilities. And generally, we suggest that if they're offered, if you're coming into the job market now as a young employee and they're offered, now would be the time to buy into them. Just as when we check off the box about life insurance, that would be a good time, because the older we get, the more expensive they get, because the risk of illness is higher. But that's often confused. Health insurance does not include long-term care insurance.
Okay. Also, does private insurance stop after a certain age where a person will have to file for Medicaid once they become elderly?
So go ahead, Patricia.
No, I was just going to say it depends on the plan.
Okay. Next question. Do you have to file a copy of your trust in order for it to be legitimately recognized?
One of the biggest dangers with trusts is that people create these wonderful trust documents, but they never put anything in the trust. And when we say put something in the trust, that all your assets have to be retitled. So for example, I see Jasmine Baird, you asked the question. And so if you have a house, Jasmine, and you'd like to put it in your trust, right, you create this, you work with an attorney, you get this wonderful trust document for, with this house in it, right? You're saying in the document, it says the house is in the trust, right? But if you never go to change the deed from the deed's ownership from Jasmine Baird to Jasmine Baird Trust, then in essence, it's like there's nothing in the trust. So the important piece about trust is that you have to get documents and assets retitled so that way it can be valid. And then in that case, usually you can provide like a death certificate in a situation where it was provided to you in an intestate in a testamentary document.
There was also, I noticed it said file a copy, and I'm not clear, is that Jasmine? If she meant file a copy where? In court? Because if that's what you mean, it does not have to be filed in court. I mean, you can file it, but it's not necessary to file your trust agreement in court.
I want to piggyback on that, Elizabeth, and say I recommend that you file the will in court, because when you become incapacitated,
yes,
or you're showing signs of a decline, people take advantage of you. It could be the home health aide that's looking after you, that convinces you to sign this will that leaves them the $1 million that you have. It could be that son who you haven't seen for however long that suddenly pops up and gets into a fight with sister, and sister gets frustrated. And then when mom passes away, suddenly the will that sister had locked away in the safe and pulls out of the safe is met with another will that says, hey, mom signed this will on such and such a date. It actually, your will is no good, and now this is the new will. So especially for my senior clients, I actually push them to pay that, $35 fee, and have the court keep the will in safekeeping so that the will doesn't disappear or something untoward happens by the time, mom or dad passes away.
Yeah, I do the same with certain of my senior clients.
Mm-hmm.
I strongly recommend, by twisting their arms, that they file their wills for safe. It's only for safekeeping. You can always go back and get it and revise it if you hit the lotto or what have you. But just as Vivian says, people will take advantage, and we see it day in, day out. Not only home health aides, I don't want to disparage home health aides, but not only to people coming into your home, but your relatives as well. And on the trust agreement, I see from Adrian, on the insurance, on the trust, make sure you add the trustees as additional insureds on the trust. So, because what you're doing is you are transferring or retitling, as Patricia said, your assets, but it's going into the names of individuals, not the trust. It's going into the names of your trustees, and they have to be insured as well.
Elizabeth, as you speak about insurance, you also mentioned in your introduction about that policy that's left to a beneficiary, but it was supposed to cover the funeral expenses. So I've kind of started encouraging my clients to split that policy. If you want that policy to pay for your funeral expenses, then make sure you first you probably want to leave it with the trusted child. But sometimes even the trusted child changes face after death, right? So you probably want to leave a part of that to the estate with specific language in your will that the policy number so and so is to cover funeral expenses. And if one of the other children puts up the monies to pay for that funeral expense, you know, that they know for sure that there's money to be reimbursed. But don't depend on I told so and so, because once there is death, nobody remembers. It's very few times that a family will actually agree that this is what mom wanted, dad wanted, and we're gonna honor those wishes. Many times it's my money. And now you have a problem within the family in terms of how those funeral expenses are being paid for. So that's definitely a discussion that should be had, and it should be carved out in a way that mom's wishes or dad's wishes or whoever, your wishes are carried out upon death. But it happens all the time. I get the funeral directors calling me, you know, what can we do? You know, we have the body, everything's done. We thought we had the policy, but now so-and-so won't sign the assignment form to assign the proceeds to the funeral home. So we just want to be careful of that.
Also, I am now encouraging, and I'm asked to establish pre-need accounts. And that will take care of your wishes. If you establish your own pre-need account and you designate, other than your surviving spouse, if there's no surviving spouse, you should designate someone to handle the disposition of your remains in accordance with your wishes.
Right. And if say Blackshear ended up with a guardian, he has $65,000 in liquid assets. Once the guardian marshals that $65,000, the initial responsibility and directive from the court is that the guardian establish a prepaid funeral fund for the incapacitated person. So he would be covered once the guardian is appointed, whether it's a family member or someone else. That prepaid funeral plan has to be established, and the court examiner usually very diligent in terms of making sure that proof of that prepaid funeral fund is provided to the court examiner. So that's another way that will work. That works under the guardianship. So pretty much most of the incapacitated persons have a prepaid funeral fund because there is follow-up and it's mandatory. And, a court examiner will bring a motion to the court to compel the guardian to do that prepaid funeral fund. So, it's a critical part of everything that we're doing to protect the interests of an incapacitated person.
So I have one additional question that was sent via text, so it's not in the chat. If a person is unclear about an elderly person's judgment, or if they're under duress, so in other words, if they're in sound mind when they made changes to a will, what is the procedure for contesting that?
That's difficult. Go ahead, Elizabeth.
No,
Yeah.
Would you repeat, if a person is?
If someone is unclear about an elderly person's judgment, or they're not sure if they're under duress as they change their will, what is the procedure to follow through on that, to contest that?
I just want to be clear, the person who is making a will, and it's possible that they're making it under the influence of someone else, because I heard duress there and it says, so.
Yes, it sounds like either duress or they're not sure of the person's judgment.
So if that can be difficult, because a lot of times we as individuals do not realize what we don't know. And we think we are functioning as, we were at X point in our lives, but it's someone else who has picked up that there is a little slippage, and that there is a person or persons who is giving information to you or to the individual, or in some way sort of changing their way of thought in a gentle way, nothing overt, nothing, but then the person starts talking and you're hearing things that you thought they never would say and never would have said. Ideally, it would be good if they would agree to an evaluation, all the things that the indicators that would help us to see that we need some additional assistance and maybe we're not making the best decisions at the time. But I find it difficult to have someone actually, acknowledge that he, she, me may be experiencing some, I don't want to say even dementia, but I would say we're beginning to think in a different way than we originally did. And it's hard to try to re-steer, because now you have someone else sort of like whispering in their ears certain things, and that's going to change their estate plan, So I think someone mentioned before about how the bank accounts get changed and how this and that and the other, those things come into play. So my colleagues may have something else to say.
Yeah, I'll just add on to that to say it also depends on how the second will was done. Because if the will was done with an attorney draftsperson, as an attorney, we have a responsibility to make certain assessments with respect to whether or not the person sitting before us has the capacity to sign a will. So if that will is prepared by an attorney draftsperson who met with the testator independent of anyone being in the room with the attorney and the testator, and the attorney felt from not necessarily one conversation, but a few conversations with the person that they have the capacity, then the court would uphold that particular will. Because the issue with someone being, especially with dementia, people have lucid moments and then they don't have such lucid moments. So the will could be executed in a time when the individual was lucid. So the person who is challenging the will has the burden to show that the testator lacked capacity when that will was executed.
And also the new power of attorney, I just, for those who may not generally come in contact with it, 2021, there was a new power of attorney format and law implemented. So banks or their representatives now, if they think that the person sitting in front of them is acting not of their own accord, and they have some suspect, and I think you've heard this about Wendy Williams with Wells Fargo, the banks will have a time frame in which they can refuse to honor a power of attorney under the new law. But after that, there are certain processes that have to be followed, because they said individuals, where Vivia was talking about when making the will, oftentimes individuals have gone into the banks and had the accounts changed. And it didn't really affect the will, because the will doesn't come into play until a person passes away.
Well, okay, thank you. Thank you. I believe I do not see any further questions in the chat. We have exhausted all of the questions. So at this time, I would like to say on behalf of our organization, Alpha Kappa Alpha Sorority Incorporated, Epsilon Pi Omega Chapter, we really thank you for sharing your expertise, your time, developing a scenario for us to help guide us through some of this information. We recognize that this information can be a little dense, a little difficult. to understand. So we really thank you for really doing this community service and sharing all of this tonight with all of us and allowing us to ask you questions. And so we thank you, each and every one of you. Everyone has the flyer. I believe they can reach out. And this comes to the end of our program this evening. So is there anything further, Ms. Gill?
I'm looking at a new message. It says 4 new messages. I just went over, do you see that? There's a red.
So the messages I am seeing seem
It
to
says-
be lots of good information. Thank you.
Oh.
Very
I
helpful
thought
and
it was a
informative.
question.
Excellent. Thank you and good night. Excellent presentation. Thank you. Great information. Awesome. Will the recording be available for the attendees? And the answer is yes. Thank you. Excellent program. Those are the comments in case you weren't able to read them. And
No, I'm
yeah.
sorry.
Oh, no, don't be sorry at all.
I thought it was a question.
No, we definitely exhausted the questions in the chat, but yes, you're just seeing lots and lots of appreciation to all of you for your time and expertise
for
this
having
evening.
us.
So everyone, thank you again. Thank you to the participants for attending. We appreciate you and thank you for pulling this together for us this week, as well as the Justice 2 weeks ago,
Yes.
Miss Elizabeth Gill and Miss Patricia Cooper. We thank you. Everyone, have a wonderful, wonderful evening and build your economic legacy.